4 for Journalism 302 in the summer of 2017. In the 3 introductory lectures, you've seen how the courts work. We saw the case of Liebeck versus McDonald's. You've looked at philosophies that advocate for and against freedom of expression. And here in these and subsequent lectures, we're going to turn to substantive law. That is to say, the actual law that is used. It's interesting. The philosophies that you've seen, they can help explain or rationalize the reasons that courts rule the way they do. But when it comes to court cases, and very importantly for you on exams, you're going to have to refer to substantive law, the court cases, the precedents, and the rules that will help you resolve controversies. As you saw in the one lecture about the libel case, there are rules that have to be applied. You'll notice that in that example question, I didn't go into philosophies for freedom of expression because they're philosophies. They aren't actually the law. So it's good for you to understand philosophies. They're very helpful to us. They often are discussed in the opinions that lead to substantive law. But I warn you against saying something like marketplace of ideas, therefore the government can't restrict speech. The philosophy may be invoked by a judge in explaining his reasoning, but it's the actual rule that you're going to have to apply. Second thing to think about is that we're going to be talking about some bad stuff. Speech is a tool. It can be used to build things, but speech also can be a weapon. It can be used to damage and harm things. We're going to talk about some cases that involve conduct which, well, it's disgusting. I'm not going to make you actually look at the disgusting speech, but we will talk about the cases and I will describe some of the content that you will probably find to be distasteful. All right, so let's move on. We're getting into substantive law. We're moving away from philosophies, which are nice to have in the background, but here are the rules of law that you're going to be using on the exam and in your professional careers. So, the First Amendment. Here we're talking about protecting speech, and of course the First Amendment is the core. You'll know that the First Amendment starts with the 5 words, Congress shall make no law. And the Supreme Court for many years considered that to be a restriction on what the First Amendment protected. The Supreme Court held that the First Amendment protected speech against federal action, that is to say, action by the federal government, laws passed by Congress, actions by the executive branch, but that was the limitation. And states were not subject to First Amendment restrictions. If your state wanted to pass a law making it a crime to publish the name of the governor, the First Amendment didn't protect that. It was subject to states. Now, every state constitution has provisions to protect expression, but as we'll see from some court cases, those state constitutional protections were not always very effective. So here we are, the First Amendment applying to the federal government, but we know today that the First Amendment does apply to both state and local efforts to restrict speech. When did that happen? Well, it happened in 1925 in the case of Benjamin Getlow versus the state of New York. Mr. Getlow was convicted of violating the criminal anarchy statute in New York. For those of you who are not familiar with criminal anarchy, it is a crime to work to destroy established order. At the turn of the previous century, there were people who said that society wasn't working, that the wealth of the nation was concentrated in the hands of a very few people, and most folks didn't have a whole lot of money. Neither did they have effective political party because the people with wealth controlled the political system. So folks said, we need to change this. Some advocated communism, in which there would be collective ownership of the means of production. Some advocated socialism, in which private property rights would give way to the needs of the members of society. Some advocated anarchy, which said we should have no established system. And it was more than just a philosophical discussion, because people took steps to destroy the established order. There were assassinations, there were bombings, and of course society responded to this by passing a lot of laws making it a crime to advocate these things. So Mr. Gitlow and his friends circulated a pamphlet called the Left-Wing Manifesto, which was advocating communist socialism. So it was a 2-for-1. And the manifesto said, take the money out of the few, redistribute the wealth to the whole of society. And of course that scared the heck out of the people who were in charge of society and the political system. He was arrested, charged, convicted, and sent to prison. Then he appealed to the United States Supreme Court, and surprisingly the Supreme Court took the case. The Supreme Court did two things. The first you can see on your screen. The most important thing, the court held that the First Amendment was a fundamental right that applied to the individual states through the operation of the 14th Amendment. You'll recall from your history classes that the 13th, 14th, and 15th Amendment, the post-Civil War amendments, were created to ensure that everybody would enjoy the protections of the Constitution. Everyone would enjoy equal protection under the law. So now in 1925, the Supreme Court holds that if a state passes a law, or even a local community passes a law that violates people's expressive rights, the First Amendment could be applied to hold that law to be unconstitutional. Oh, the second thing the Supreme Court did, which is not as important, well, at least to us, but very important to Mr. Gitlow, was they upheld his conviction. They said, Mr. Gitlow, you're in prison, you're staying in prison. But case important for all of us because it nationalized the First Amendment. Now, it's not just the First Amendment to protect speech. We also have protection under the Fifth Amendment. The Fifth Amendment, of course, you're familiar with it, not being compelled to testify. But the second part of the amendment, the Due Process Clause, says that they can't take away your life or your liberty or your property unless they follow due process of law. And this is significant to us. Our case from the textbook Southeastern Promotions versus Conrad, this is a case involving an off-Broadway musical play which subsequently went on Broadway. The play was called Hair. It was written and produced during the period of the Vietnam War, and it was an anti-war musical, hippie musical. It opposed the war. It said terrible things about President Richard Nixon. It had a number of songs that are still popular today. It probably was most famous because it involved the entire cast disrobing at the end of the first act and the audience being confronted with full frontal nudity. Now, this was produced off-Broadway at the time, but it was a popular musical. Some years later, somebody brought out a traveling production of Hair. It was going to play in an auditorium operated by a county official. Learning that Hair was the production, said, you can't show that terrible play in the county auditorium because it has hippies, references to drugs, it has full frontal nudity, and it says terrible things about now former President Richard Nixon. And he locked him out. The company that was running the traveling production sued. And in that case, the court held that the theater production being locked out of the theater without a court hearing, without being able to challenge that action, was denied due process of law. So if you are in the government and you want to prevent something from being expressed, something from being put on, you have to go through the process of getting a court to agree with you that the production or the expression should not take place. And the persons whose speech is being denied have to have the opportunity to speak to that and make their own arguments to the court so that the judge can consider both sides before rendering a judgment. And so in this case, in Southeastern Productions, there was no such hearing. The county official just took it upon himself to lock out the production, and that deprived Southeastern Promotions of due process of law. One thing to keep in mind is that due process does not mean fairness. Due process simply means that there is a procedure that has to be followed. For example, I used to be a journalism department chair back at Idaho State University. I also taught classes. If a student wanted to contest a grade in one of my classes, they of course would, that student would come to me, make an argument, and I would say, well, yes, I'm changing the grade or I'm not changing the grade. If I didn't change the grade, the student could appeal, and the student would appeal to the department chair, me. So I, the faculty member who said, no, I'm not changing your grade, would now be the department chair sitting in judgment of the faculty member saying, I'm not going to change your grade. And so if a student appealed to the department chair, not that this happened, I would be able to say, no, I am not going to change the decision by the faculty member, and the student would have gotten due process. Now, the student probably would have said that's not fair, but it is the procedure that was in place. Not to worry, even if a department chair doesn't agree in endorsing his decisions as faculty member, students still have the opportunity to go up the chain to appeal a grade to the Office of Student Rights and Responsibility, ultimately the provost and the president. But just understand that due process means that there is a procedure that has to be followed, and if you don't follow it, then your action is not constitutional.